the impacts that other actors had on the crime,
Okay.
For better or for worse.
Okay.
And any other thing that may be a mitigating factor for me that would lighten my view of that.
All right. So you heard me describe the process of a penalty phase. There's
Correct.
states presented aggravators, defenses presented their mitigators. You're required to, with an open mind, weigh those. You can assign whatever weight you wish and you believe is correct to a mitigator or an aggravator, but you have to be able to at least listen and weigh them fairly. If at the end of that you felt that the evidence, the facts, the mitigators, the aggravators, all of it led you to believe that the appropriate sentence was life without the possibility of parole, would you be able to vote for that sentence?
Yes.
And same, if you felt that the appropriate sentence was death, would you be able to vote for that sentence?
Yes.
All right, let me move on to the insanity defense. I explained to you that Mr. Loyd has raised that defense, and this is in the guilt phase when you're trying to decide whether or not he's guilty of the crimes he's charged with. If the burden's on the defense, this is the only time it's on them to prove by clear and convincing. If they prove to you that he was insane at the time of the offense, would you be able to return a verdict of not guilty by reason of insanity?
Yes.
Okay. And lastly, as I indicated to you, he's already been convicted of the murder of Ms. Dixon and her unborn child, and sentenced to life in prison. Those facts cannot be used in determining whether or not he's guilty. You'll have to put that out of your mind. Do you believe that you can do that?
I understand that I'm supposed to do that, but it's hard to unring the bell when you hear something. So I can't say with 100% certainty that that would not be a quiet voice in my head that had also occurred.
When you were deciding whether or not this was, the charges, first-degree murder, attempted murder?
Correct. Okay. I see. It's hard for me not to formulate a pattern there.
Okay.
That a prior act, even though it's not supposed to be a consideration in a current trial, would not be something that would lean into my thinking a little bit.
All right.
State moves.
Any objections? All right, you're doing this one, Ms. Miller? You're okay. All right, sir. Based on that, I think this isn't the case for you. We appreciate your time and your willingness to serve, but you're excused.
Thank you.
Thank you. I'm sorry, he's juror number, let me not do this without my glasses.
386.
386, thank you.
Okay,
All right. All right, the juror in seat number 3, please. Okay, great. Juror number 5 has arrived.
Hello.
Hi, how are you?
I'm good. How are you?
I'm well, thank you. Welcome back. Did you have a good lunch?
Yeah, I did.
All right, since you were here last on Friday, has anybody talked to you? Have
No,
you
they
seen
have
any
not.
stories about the case, anything at all?
No, they have not.
All right. Had you previously heard anything about this case prior to coming here?
No, I have not.
All right. I noticed that you're a full-time student, and I'm sorry, just for the record, you're juror number 914, correct?
Yes, I am.
Okay. I noticed that you're a full-time student, okay? Is being here for, let's say you were picked for the jury and you're sequestered for 3 weeks, is that going to interfere with your studies?
I have some classes that I have to be at, but for now, no.
For now, no? Okay. Tell me about the classes you have to be at.
I have classes on Thursday that I have to attend at from 9 to 11, and then I have other classes that are online, but I have to be in the online class too, at a specific time.
If you're chosen as a juror in this case, you can't be at that Thursday class and you can't be on the online ones. And the only time you can be in class is after we've recessed for the day. And most days we run till 5:30 or 6.
Oh, okay.
So is that going to be a problem for you?
I will have to ask my professors about it.
Okay. Do you have any moral or religious objections to the death penalty?
I believe that the death penalty is justifiable.
You don't believe it's justifiable?
No, I do.
You do?
In certain cases, yes.
Okay. So are you someone who's opposed to the death penalty in all cases?
Not, well, yes and no.
Yes and no? What does that mean?
So yes, if it's a certain case that needs to be the death penalty, but in other cases, no.
Okay. Let me take this off because you heard me describe the process that jurors go through
Yes.
if we reach a penalty phase in this case. You know, you have to listen to the state's evidence of the aggravators, the reasons they believe death is appropriate. The defense has mitigation, mitigators, the reasons they believe life without parole should be your vote. Then you go back into the jury room with instructions from me on the law. You all can discuss it as much or as little as you like, but you are required to weigh those aggravators and mitigators with an open mind. Think about everything you've heard, and in the end, you have to vote. You yourself have to take an independent vote on whether or not you believe life or death is the appropriate sentence. If after going through that process and weighing everything and taking as much time as you need to make a decision, you decided that life was the appropriate sentence in this case, could you vote for that?
Yes.
And if, on the other hand, you decided that death was the appropriate sentence in this case, could you vote for that?
It would depend
On what?
on the evidence.
Okay, well, it does depend on that, all right? The aggravators, the state has to prove at least one aggravator beyond a reasonable doubt before you can even consider death, all right? You're not required ever to vote for death. Even if you think it's the appropriate sentence, you can vote for life just because that's what you want to do. That's what you think should be done, all right? But my point is this: if the evidence and everything that you've heard in court led you to believe that death was the appropriate sentence, you've listened to everything, you have all the evidence, and based on that and the aggravators and the mitigators, you believe death is the appropriate sentence, could you vote to impose a death sentence?
Yes, I could.
All right. The insanity defense, as I explained, Mr. Loyd has raised that defense. That would occur in the guilt phase, not the penalty phase. In the guilt phase of the trial, when you're trying to decide whether he's guilty or not. The burden is on the defense. It's the only time it is in the guilt phase. They have to prove it by clear and convincing evidence. But assume hypothetically at the end of the trial, of the guilt phase, you believe they had proved it and that Mr. Loyd was insane at the time of the offense. Would you return a verdict of not guilty?
Yes, I would.
All right. And then lastly, as I told you, he's been previously convicted of the murder of Miss Dixon, Sade Dixon, and her unborn child. She was pregnant at the time. And he was sentenced to life in prison without the possibility of parole. Those facts cannot be used by you to decide whether he's guilty or not of these charges. Do you understand that?
Yes, I do.
Can you follow that instruction?
Yes, I can.
You can put it out of your mind.
Yes.
All right. Thank you, ma'am. I'm going to turn this over to the attorneys. Mr. Williams, you may inquire.
Thank you, Your Honor. Good afternoon. What is it that you are studying in school?
I'm starting to become a teacher.
Okay. Do you know what subject or even age group you want to teach?
First elementary.
Okay, you want to teach elementary school. And I noticed on your the questions you filled out, the answers for jury selection, that you've only lived in Orange County for about a year.
Yes.
May I ask where you came from? What other place you came from?
I came from West Palm Beach, Florida.
Okay. Is that where you grew up?
Yes, yes.
Did you come for school?
Yes, I came here for school.
Okay. So, are you in your first or second year of college?
I'm in my second year.
Second year. So let's just say that you went to class next week and you were not selected as a juror. And the professor told all of the students, you have to write a paper, a page in length only, and you have to take a position on whether or not the state of Florida should have the death penalty, either pro or con. You have to be able to defend your position with reasons. You with me?
Yes.
You can't pick both sides and do both in the same paper. You have to choose one, and everybody will choose something different. Which side would you select to defend and why?
Con, because I believe the death penalty is not good. It's not good.
Okay. And so you would pick con. What would your explanation or reasons be for why the death penalty is not good?
The death penalty, I believe, does not do good for the human justice system, and in some cases the death penalty is justifiable, but in most cases no.
And I heard you use that phrase with Judge Marquez, so I apologize, I wasn't looking at you the whole time, I'm trying to take notes. Justifiable. What circumstances do you have in your mind when you say that in some cases it's justifiable?
In some cases, if the person who did the wrong thing had a lot of evidence built up to them that I believe was not good, then yes, the death penalty would be good for them.
So what do you mean specifically, okay, as specifically as you can, when you say that the death penalty is not good for society? What aspects of it and its impact on society are you referring to?
The moral side.
The moral side, okay. And when you say the moral side, flesh that out for me, just like you would if you were writing that paper and the professor's like, no, you have to provide justification for your answer. That kind of.
Morals would be in yourself, your beliefs. So religion in that sense.
Okay. Does it impact your moral or religious beliefs?
Yes.
All right. Tell me about that. Let's start with, because those are two different things. Let's start with the religious belief. What religious belief do you personally hold in regards to the death penalty?
Well, I'm a Buddhist, if that is good, and I believe that death penalty is not good in my beliefs.
It's not what? I'm sorry.
It's not good for my beliefs.
Okay. And forgive me, but I don't really know what Buddhists believe about the death penalty. What aspect of your religion or faith, what does it say about the death penalty?
Well, in my religion, it says that the death penalty should be justifiable, but in my sense, I believe that the death penalty is not good.
Not good. Okay. From a moral standpoint, how are you thinking about the death penalty as that it's not good morally?
Say that question again, sorry.
Sure. So I asked you first about the religious standpoint, and then I said that moral is different than religious. So how is your moral belief framed about the death penalty?
I believe that in my morals that the death penalty is not good, but it is justifiable.
Okay. So some people in some religions say a version of this. We as humans don't have the right to decide another human dies. Have you heard that phrase?
Yes, I have.
Do you agree with that phrase?
It depends.
It depends. What I'm hearing you say is that most of the time you agree with that phrase. Is that a yes?
Yes.
Okay.
Yes, sorry.
That's okay. She has to take it down. I didn't mean to get on you. But I also hear you saying that, and I'm paraphrasing, if I'm wrong, tell me, if it's really bad, then you could do it.
Yes.
Okay. Is that an accurate summary of where you are on this?
Yes, I am. Yes.
Okay. So what does really bad mean?
Really bad is if they killed a lot of people, they did like bad stuff. They are serial killer, like a shooter.
So, serial killers, genocide, things like that.
Yes.
Is that a yes?
Yes. Sorry.
But do I hear you saying that anything short of that enters that moral and religious problem that you have?
Yes.
Okay. Could I have a moment, Judge?
You may.
Those are the only questions I have. Thank you very much, ma'am.
Thank you.
Thank you, Mr. Williams. Ms. Miller, any questions? Good afternoon.
Good afternoon. Hello.
Hi. I just want to clear up a couple things. The law in Florida requires for a juror to serve on a capital case, one where death is a possible penalty, that juror to be able to give meaningful consideration to both possible penalties for first-degree murder. The life penalty and the death penalty.
Yes. Yes.
I'm hearing you say, can you give meaningful consideration to both possible penalties if we end up in a penalty phase in this case?
Yes, I could.
Okay, thank you. And I think that we maybe got hung up. I think I heard you say that death would be the appropriate penalty if somebody was guilty, or you felt very strongly of that person's guilt.
Yes.
Okay. And so I think you heard the judge, or did you hear the judge ask, is there a certain type of, scratch that. If someone is convicted for premeditated first-degree murder, would the death penalty be automatic? And you said
Yes.
no.
Yes.
Okay. Let's just break that apart a little bit. All right. First-degree murder in Florida is the intentional, premeditated killing of an innocent victim.
Yes.
Okay? If somebody was found guilty of first-degree premeditated intentional murder, any defense that was available to that person would have been rejected by the jury that found him guilty.
Yes.
Okay? Things like, just for example, self-defense, heat of passion, walks in, catches his wife in bed with another man, duress, none of those things would have applied because that
Yes.
jury would have found him guilty. No mistake, no accident, the police definitely got the right path. Okay? That's what, if we're talking about penalty, that person is unequivocally guilty of intentional, premeditated first-degree murder.
Yes.
So is the death penalty automatic for that person who committed that intentional killing without legal excuse, justification, or defense?
Grounds? Without facts, just short.
This juror will never be presented with that scenario.
Overruled.
You can answer that. So the question is, for somebody who's guilty of intentional premeditated first-degree murder without legal excuse, justification, or defense, is death the automatic penalty for you?
Yes.
May I have just a moment, Your Honor?
Sure.
Thanks. I don't have any further questions. I have a motion for the court.
State, you have a motion?
Yes, but I'd like to approach if possible.
She's making a motion also. I think you're,
I understand.
But
I'd
you
still
want
like to approach- If the court were permitted, I'd still like to approach.
sure, come on up.
All right, ma'am. I don't think this is the case for you, given that it's a death penalty case, so we're going to excuse you with everyone's thanks for being willing to serve.
Okay,
All right?
thank you.
Good luck to you. Thanks.
So I don't have to come back anymore then?
You don't. You're free to go.
Okay, thank you so much.
You're very welcome.
Thank you.
Thank you.
Have a good day.
Thank you, you too. Juror in seat number 4, please. Good afternoon. How are you?
Good.
Can you hear me clearly through this mask?
Yes, ma'am.
Okay. As I said, we have a few questions for you. I'm going to go first, then the lawyers are going to get to ask you some questions. Try to relax. It's not as painful as it appears. We're not looking for any particular answers from you. We just need you, there's no right or wrong answers to these questions. It's just what you actually think and feel. You understand that?
Yes, ma'am.
Okay. Let me start by asking you, you said you'd heard something about this case. Can you tell me what you've heard?
All I remember is the name and seeing something, maybe, I don't watch TV or anything. We don't even have cable. So I just remember seeing something maybe on my phone pop up.
Okay.
But I don't really remember any details because I don't keep up with a lot of things like that.
Over the years, has anybody talked to you about the case? Have you heard people
no.
talking about it?
No, ma'am.
All right. As a result of what you heard, did you form any opinion as to whether or not Mr. Loyd is guilty?
No, ma'am.
All right. Jurors have to be able to presume he's innocent until and if the state proves he's guilty beyond a reasonable doubt. Can you do that?
Yes, ma'am.
Do you have any moral or religious objections to the death penalty?
I don't have strong feelings either way, really. It's nothing I've ever thought much about.
Okay. In cases like this, if you ended up in a penalty phase, as I explained to you, the state's going to present their aggravators. The defense is going to present their mitigators. You're going to go back in the jury room with instructions from me on what the law is. You and your fellow jurors can discuss it as much or as little as you'd like. It's really up to you. But in the end, you're going to have to make a decision, an individual decision. You're going to have to weigh the aggravators and the mitigators, and you assign whatever weight you feel is important to each of these factors. You can consider everything that you've heard throughout the case, weighing those aggravators and mitigators. You have to reach a verdict. So if after going through that process, you felt that the appropriate sentence was life without parole, could you vote for that?
Yes.
And the same, if after you went through the process, you felt that the appropriate sentence was death, could you vote for that?
Yes.
Do you have any doubt in your mind about your ability to do one or the other?
No.
The insanity defense, as I told you, Mr. Loyd has raised that defense. So this would be in the guilt phase of the trial, the first phase, when you're trying to decide whether he's guilty or not. If after you've heard all the evidence, and again, the defense has to prove that. It's the one time in a guilt phase that a defendant has to prove something by clear and convincing evidence. Let's say they put on all their evidence, they put all their evidence on. It's the end of the guilt phase, and you believe he was insane at the time of the offense. Would you be able to return a verdict of not guilty by reason of insanity?
Yes.
And lastly, as I told you, he has been convicted of the murder of Sade Dixon and her unborn child. She was pregnant at the time. And he was sentenced to life in prison without the possibility of parole. You can't use that in any way, shape, or form to decide whether or not he's guilty of these charges. Do you understand that?
Understood.
Do you have any doubt in your mind that you can put that aside and not think about it during the guilt phase?
No.
All right, thank you, ma'am. I don't have any other questions for you. The attorneys might. Mr. Williams, you may inquire.
Thank you. Thank you, Your Honor. Good afternoon. So I take from your response that there's never been a time where you had the opportunity or chose to sit down and think about the death penalty?
No, sir.
Okay. So in that circumstance, I'd like to walk you through the process a little bit to see if maybe that allows you to think about it and how you feel about it. So that only becomes an issue if Mr. Loyd is convicted of first-degree murder, right?
Yes, sir.
And what would happen next is you would sit with the other jurors and the state would present evidence of what are called aggravating factors. And those are things that are just like they sound. Things about the way the murder was committed, or maybe the nature of the victim, or even something about the defendant's past that make the commission of this first-degree murder more severe than one that lacks those aggravators, which makes sense because that has to be proven for the death penalty to be an option as opposed to not. You understand?
Understood.
Okay. And I'm not trying to talk down to you. I know that it's a lot to take in. After we present the evidence of those aggravating factors, the defense, if they wish, would have the option to present evidence of mitigating circumstances. And those are just like they sound, things about Mr. Loyd's background, character, or life that they believe are reasons why a life sentence without possibility of parole will be more appropriate. If and only if the jury unanimously finds that at least one aggravating factor is proven beyond a reasonable doubt, you'd be asked to weigh the aggravating factors against the mitigating circumstances. You as a juror, as an individual, will decide how much weight to give to each aggravating factor and each mitigating circumstance. It's not a mathematical formula where you add up the number of ags against the number of mitigators. Make sense?
Yes, sir.
As you can imagine, some things about some things are going to be more important to you than others. And if you believed that the aggravating factors outweighed the mitigating circumstances, you would be authorized under law to vote to have a sentence of death imposed upon Mr. Loyd. Does all that make sense to you?
Yes, sir.
Anything about that process that you think you could not participate in given your life experiences?
No, sir.
Let's say you go through that process and at the end of it, you believe that we've proven one aggravating factor, and you believe that the aggravating factors outweigh the mitigating circumstances, and you believe your reasoned moral judgment is that a sentence of death is appropriate in this case. Could you go back to the jury room and raise your hand and say, yes, I vote that a sentence of death be imposed?
I believe so.
Okay. And the last part of my question, on another human being. And I say that because believe so is a little bit of an equivocation. So tell me about the I believe so part.
Just that I do value life, but I also believe that we could be accountable for our actions.
Right.
And I do have a strong moral compass, I believe. So I've never had to make that decision, but I believe I could,
Okay.
if needed to.
So even though, am I accurately stating it, that that decision would be difficult?
Correct.
But you think if moved in that direction by the evidence that you could vote for death?
Correct.
All right. Conversely, even if you were really emotionally struck by the evidence from the state, could you vote for life if you thought that it hadn't been proven or you thought that's what was appropriate? Life without parole.
Right. Could I go for that if what? I'm sorry.
Yes. You're right. Could you
I
vote
just want to
for
make sure I understand the
Yes,
question.
ma'am. Yes, ma'am. Could you vote for a sentence of life in prison without parole, even if you thought that you were emotional about what you had heard? If you thought it wasn't the right sentence to vote for death, could you vote for life?
Oh, yes, sir.
Given that an insanity defense may be raised, I need to ask you some questions that are a little more personal.
Okay.
As if this isn't personal enough to begin with. Have you or anyone in your family ever suffered with mental or dealt with mental illness?
No, sir.
Okay. There are those who would say something like, I think mental illness is fake. People use it as a justification to do whatever they want. Do you agree with that statement?
I believe there really are people that struggle with mental illness, but I believe it can be taken advantage sometimes, so.
So it depends on the facts.
Correct.
All right. And do you feel that with your life experience, you could weigh the insanity defense as it was presented to you, and if the defense were to present evidence to you that proved it, that you could find that Mr. Loyd was not guilty by reason of insanity?
Yes, if
Okay.
it was proven.
Conversely, if it wasn't proven to you, you could set it aside.
Oh, yes.
All right. Is there anything in your life or background experiences that we should know about you, given that we're trying to select the most fair and impartial jury in this case? And by way of example, sometimes people say, you know, my loved one was murdered 10 years ago, and I went to the trial, and it's something I've never forgotten. Hopefully nothing like that has happened to you, but I have to ask anyway.
I have not dream like that that's happened in my life. No.
Okay? I lied. I have one more question. On a scale of 1 to 10, 1 being you're extremely anxious to get out of here and never come back to the Orange County Courthouse, and 10 being you can't wait to be a member of this jury, where would you rank your desire to be a participant as a juror in this case?
I would say a 5.
Okay.
I believe in our I want to fulfill any responsibility, but at the same time, I have a family and children.
Right.
So,
Right. And I assume because the judge asked you and you didn't speak up that if sequestered, you'd be able to handle, you or your spouse would be able to handle that situation to the best of their ability until you got back.
yes, thankfully, I have a village of people that can pitch in and help.
Awesome. Awesome. Thank you very much. Thank you, Your Honor.
Thank you, Mr. Williams. Who's next? Ms. Miller? You may inquire.
Good afternoon.
Good afternoon.
So I want to talk to you a little bit more about your feelings on the possible penalties for first-degree murder. There are only 2, life in prison without the possibility of parole and the death penalty. The judge asked you earlier if death would automatically be the penalty if you found somebody guilty for the crime of first-degree murder. Do you remember that?
I think so, yes.
Okay. It's okay if you don't. I know we're all tossing a bunch at you, right? So that's generally
Ma'am, can you move that mic up closer
I'm
to you? I
sorry.
can't hear you. Okay, go ahead, thanks.
big courtroom. So let's break that down a little bit. First-degree murder in Florida is the intentional, premeditated killing of an innocent victim. That defendant thought about it, meant to do it, and did it. And if he or she was found guilty of first-degree murder, the jury would have rejected any defense, right? Guilty of the crime of intentional, premeditated killing. So the question is death the automatic penalty for someone who is guilty of the intentional, premeditated killing of an innocent victim? For you.
Is it the automatic? I would say it varies by case in my mind. It varies by case,
Okay.
I would say.
Okay. And is there a type of case where it is the automatic penalty?
I mean, like I said, I believe that people should be held accountable for their actions. And so if it was clearly premeditated, and I've never had to think of this before, but I mean, I just, all I know to say is I feel like it would depend on the case and what's being presented.
Okay. Well, and that's why, right, we may not even get to a penalty phase in this case, right? That's only if somebody is found guilty of first-degree murder do we consider the possible penalties being life or death. But this is my only opportunity to speak to you.
Right.
And the law requires that we have this conversation now. And so, unfortunately, I can't give you a lot more facts, and I'm asking you just to look inside your heart of hearts and be as honest as you can. And I know that you don't sit at home thinking about
I've never thought of this before today, honestly, or
Right.
before this whole experience.
And so that's why it seems to me that the part you're getting hung up on is premeditation. Right? You mentioned premeditation,
Right.
right? And so that's where if somebody is guilty of first-degree murder is intentional, premeditated killing without legal justification, excuse, or defense. Tell me what your feelings are about death.
Asked and answered. Objection.
I would disagree.
I'm going to overrule. I'll allow her to answer this, but I may have some follow-ups for her. Go ahead.
Just like I stated before, I believe someone should be held responsible. And I don't know what else to say other than I feel like it varies according to if there was truly a severe, maybe mental illness to be considered, then I think it's fair for it to be considered, but only if the evidence is there for it.
Say the last part again, I'm sorry?
Only if the evidence is there for it and it's clear.
And when you say if there is a severe mental illness, do you mean if the defendant has a severe mental illness, that would be something you would potentially
Correct.
consider in weighing whether to give life?
Correct.
Okay. In the scenario that I've described, intentional premeditated killing without excuse, justification, or defense, would life in prison without the possibility of parole be a sufficient enough penalty for that person?
You're saying if they did have the mental illness?
Right, if we're just talking about first-degree murder conviction, is life without the possibility of parole a sufficient penalty for someone who commits intentional premeditated murder?
Objection, same question reversed.
The objection is sustained as to sufficient enough. It's overruled as to sufficient.
Okay, same question, no enough. So let's rephrase. Intentional premeditated first-degree murder, is life in prison without the possibility of parole a sufficient penalty for somebody who commits that crime?
You're saying if there's a mental illness?
No, we're just talking about somebody who's guilty of intentional premeditated murder.
I'm not sure that I can answer that right now without thinking more about it. I don't know if that's a answer I can give.
That
Okay.
is an answer you can give, ma'am.
Okay.
There are no right or wrong answers. If you're picked as a juror, you'll take a different oath, but right now the only oath you've taken is to tell the truth, right? And so that's totally fair. But we do need to have more of a conversation about it. Tell me what you're struggling with or what your thought process is.
I guess like I said, I've never been in this situation before, and so it's a lot to take in, and I believe I can do the job if needed. That would be at hand, but I've never dwelt on all of this before, so.
Let me ask you this. If the victim, so it's still an intentional premeditated killing of an innocent victim, if that victim is a law officer, is death the automatic penalty for someone who premeditated intentionally killed a law officer?
I believe a life is a life. Either way.
Okay. So then it's not making it, not that there is such a thing as better or worse murder. It's not leaning you one way or another because the victim is a law enforcement officer.
No, it's still a life either way.
Okay. What if the defendant committed intentional premeditated first-degree murder had also committed another intentional premeditated first-degree murder? Is death the automatic penalty? I didn't finish the question.
Yeah, finish your question and then, were you done?
No, is death the automatic penalty for somebody for this intentional premeditated first-degree murder who has a prior conviction for an intentional premeditated murder?
I'll overrule the objection. You can answer that question.
If I don't know anything about this, then I'm not sure that I could let that wait.
Okay, let's assume you know everything about it.
Right.
Tell me,
I mean, if you're saying so if they murdered more than one individual,
yep.
then it may make it harder to say that if they premeditated multiple murders, if that's what you're saying.
Okay.
Hold on, let me intervene, because I think you're getting confused, ma'am, all right? It's not the person is facing multiple murder counts. It's they're facing a murder count in this one and are convicted of it, and in their background, there was another murder. Okay? Do you understand the difference? Okay.
So that's what, we're kind of confusing two different things, right? So the judge has talked to you about Mr. Loyd and him having a prior conviction for murder, and you as a juror, if you're selected, are instructed you can't use that to decide his guilt for this case.
Right. I believe I could be fair and
Heard you, got it. Different question, right? We're talking about now somebody who's been found guilty of first-degree murder, and we're in that penalty phase, right? Where we're deciding life or death as the appropriate penalty. And you know that person that you're deciding what the appropriate penalty is, has a prior conviction for intentional premeditated first-degree murder. So is death the automatic penalty for this person for this intentional premeditated murder?
I believe I could go off of what we're doing right now versus and block out whatever.
Okay. Let me ask you a different question. You are on an island, and you are the queen of that island, and you make up the rules as the queen. What are the rules for you to make the decision about whether life or death is the appropriate penalty?
Objection.
Sustained.
Can we?
Sure. It's been good.
Okay. I want to ask you about some things that we call mitigation, right? And it's a legal term that just means why any juror would decide to give life or not give death. Okay. And aggravation is limited to one of 16 things by law. Mitigation can be absolutely anything to any juror. With me? Yes, you have to answer
Yes.
loud. If you heard that a defendant had been subjected to the effects of racism over the course of his life, do you think that's something you could give meaningful consideration to in deciding whether the appropriate penalty is life or death?
If they had been exposed to racism,
Yes.
I don't feel like that would make a difference in life or death for murder.
Okay. And the legal standard is be able to give meaningful consideration to, right? And you seem like a thoughtful person. I don't think you're going to sit there and be like, la, 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 not listening. But if I'm hearing you correctly, that isn't something that, if you're being honest, that you're going to consider meaningfully as to what would be the appropriate penalty.
No, I don't think so.
Okay. Similarly, if a defendant had been well behaved in jail pending trial, is that something that you're going to give consideration, meaningful consideration to when deciding whether life or death is the appropriate penalty?
I'm not sure that that would make a difference in my mind.
Okay. The defendant having a tough upbringing, is that something that you're going to give meaningful consideration to?
I would give consideration to it, but I believe we all have struggles and have to learn how to overcome them.
Sure. And so from hearing you, it's, everybody has some hardships. Okay. You would not be surprised to learn that 12 people selected for a jury on something like this often have very differing opinions. Fair?
Yes.
And the law allows that and contemplates, right? So if we get to this penalty phase, each juror is expected to render an individual moral assessment about whether the penalty is life or death. Fair?
Understood.
Okay. And death is never required, not in any case, not in this case, not in the worst imaginable case. Okay? And what's important for justice to be heard in this courtroom, all 12 jurors have to have their individual moral assessment reflected on that verdict form. There's one signature, but it's the foreperson saying, this reflects all 12 of our individual moral assessments. With me?
Yes.
Sometimes things can get a little heated, right? People feel strongly. And so the law also, has some rights that you have as jurors, and one of those is not to be bullied or badgered by a fellow juror. Fair?
Yes.
You would not bully or badger a juror to agree with you, correct?
Correct.
And you're not going to stand by while somebody else bullies or badgers somebody to change his
That
or her.
is the opposite of who I am.
Okay. May I have just a moment, Your Honor?
Yes, ma'am.
She can't consider any of the mitigation.
Right, and do I have more questions for this juror? I have no more questions, but I gave a motion for the court.
All right, let me see she says she has no more questions, but she has a motion. Let me see the attorneys at the bench. All right, ma'am. You've been more than patient. We appreciate your time and your effort. I'm going to excuse you from this jury. We appreciate your willingness to serve, honestly,
you.
more than you even imagined. So you are free to get on with your life. You're discharged as a juror in this
All right,
case.
and thank you all for all what you do.
Juror in seat number 5.
Have a seat here.
Good afternoon, sir. How are you?
I'm doing good.
All right. You were going to check and see if your employer would pay you if you were here for 3 weeks. Is that correct?
Yeah.
And did you check?
Yeah, I checked.
Do they pay you if you're here for 3 weeks?
No.
And if you're not getting paid, can you afford to pay your bills?
I mean, I pay car insurance for myself, but
I can't hear you,
I
sir.
pay car insurance for my car, so I don't think so.
So you don't believe you can pay your bills?
No.
All right. State,
State moves.
defense. You may, yeah. All right. Thank you, sir. You're free to go.
All right, thank you.
Juror in seat number 6, please. Good afternoon, ma'am. How are you?
I'm good. How about you?
Just fine, thanks. Sorry it's taken so long to get you in here. Did you have a good lunch?
Yes, I did.
Okay, good. So we have a few questions for you. Try to relax. I know that's hard to do in this situation, but try to relax. It's not a test. There aren't any right or wrong answers. We just need you to be honest with us, okay? First of all, I just want to clarify, you're Juror 880.
Yes.
And you've not heard anything about this case, is that correct?
Well, after lunch, I pretty much kind of like remember hearing something,
Okay.
but not clearly, because I don't have cable at my house. Just,
Okay.
coworkers talking about it, but didn't Google it or something like, okay, what's
You
about
just
it? We'll
vaguely remember somebody talking about this case?
Exactly, yeah.
All right. So is there anything about that, well, let me ask it this way. Is anything that you've heard made you think that Mr. Loyd is guilty of this of the charges?
Again, I don't know much of the details, so I just hear like pretty much what was
All right.
over coworkers were chatting about, and that was pretty much it. I don't know facts. I don't know any much about the case.
All right, so as you sit here today, the law requires you to presume him to be innocent until and if the state can prove he's guilty beyond a reasonable doubt. Can you do that?
If I have the facts and if I have proof or something, that will show.
You haven't heard anything.
Oh, yeah.
Okay? So you have nothing. I read you a little tiny blurb that isn't evidence. Evidence comes from the witness stand and from things that are introduced in court. So having heard nothing, can you presume Mr. Loyd to be innocent?
If I have correct, yes.
Okay. Let me talk to you a little bit about the death penalty. Do you have any religious or moral objections to the death penalty?
I do not.
Are you someone who believes that if someone is convicted of first-degree premeditated murder, the intentional killing of another person, that they should automatically be sentenced to death?
I do.
Okay. How long have you held that belief?
Pretty much since, pretty much been from a long time. Because I don't think no one have the right to take someone else's life.
Okay. The law in Florida is the exact opposite of that, which is we don't have an automatic death penalty for first-degree murder. We just don't. It's only special cases. The state has to prove at least one aggravator. So, and you have to be able to weigh aggravators and mitigators with an open mind. You heard me explain all that to you. So if there was a conviction for premeditated first-degree murder in this case, the intentional killing of another human being, would you be able to consider a life sentence, or would you be automatically thinking this is a death sentence?
I will consider it to be the pretty much the first thing that you mentioned. Not death penalty, but the first analogy that you used.
I can't put words in your mouth, so you have to tell me.
Can you repeat then what you said,
Yes,
please?
ma'am. If there was a conviction for first-degree murder, the intentional killing of another person, and you've got to, be able to fairly consider life versus death. You just told me that you think premeditated murder, it should be death. Would you be able to fairly consider life, or would you be thinking, no, it's a premeditated murder, death is the appropriate sentence?
I can consider it to take life.
You can consider a life without the possibility of parole?
Correct, yes.
Okay. So you could weigh the aggravators and the mitigators fairly with an open mind. You've got to be open to them. You don't have to accept them, you just have to be fair about it. If in the end you decide they don't mean anything to you, that's fine. But you can't start out with, yeah, I'll just sit here until I can vote for death. Okay,
Yes.
you understand the process?
Yes, I do
And do you
understand the
believe you can do that?
Yes, I do believe I can do it.
Right. The insanity defense, Mr. Loyd has raised a defense of not guilty by reason of insanity. That's in the guilt phase when you're trying to decide whether he's guilty or not. It doesn't have anything to do with the penalty, okay? If at the end of that, this defense has to prove that. It's the only thing they have to prove in the guilt phase. And it's by clear and convincing evidence. If at the end of all the evidence, the state's put their case on, defense has put theirs on, you're sitting back in the jury room and you're convinced he was insane at the time of the offense, could you return a verdict of not guilty by reason of insanity?
Can you please repeat?
Sure. Are you having trouble hearing me?
Yes, it's
Okay.
hard. It's hard to hear you.
The defense of not guilty by reason of insanity, it's the defense's burden to prove that in the guilt phase. This is when you're trying to decide if he's guilty or not. It's the only time they have a burden in the guilt phase. And that is by clear and convincing evidence. So it's the end of the trial. The state's put all their evidence on, the defense has put all their evidence on, and you are convinced that he was, by the defense's evidence, you're convinced he was insane at the time of the offense. Would you be able to return a verdict of not guilty by reason of insanity?
Yeah.
All right, and then last question I have for you. You heard me tell you that he's already been convicted of the murder of Sade Dixon and her unborn child. She was pregnant at the time, and has received a life sentence without the possibility of parole. You can't use that information to decide whether he's guilty or not of these charges. That information comes later on to be used. Can you put that out of your mind in deciding whether or not he's guilty of these charges?
Yes.
All right, thank you, ma'am. I'm going to turn this over to the lawyers. Hold on.
Oh, sorry.
The lawyers get a chance. All right. Mr. Williams, you may inquire.
Thank you, Your Honor. Yeah, this is just getting started, unfortunately, so.
No, you're okay. I thought it was done.
So what types of projects do you engineer at your job? It says project engineer.
Yes, it's a defense company.
Okay,
So pretty much missiles and
that's enough. I know what you
sensors.
mean. I don't want to put you on the spot, given what you do. So the process that we're asking you to potentially go through can be complicated, so I want to go through it to make sure that we're on the same page, and then I understand what you're saying. I heard you say something to the effect of, no one should have the right to take a life. Did you say that?
I did.
All right. And does that mean that you sort of believe in an eye for an eye? In other words, if you take someone's life, your life should be taken?
It depends on the case. Because
Okay.
you cannot have revenge, right? So
Right. Okay. All right. Well, that's why I wanted to ask, to make sure I wasn't misunderstanding. So if and only if Mr. Loyd is convicted of first-degree murder, then all of the jurors would sit down and listen to evidence of what are called aggravating factors. And those are things about how the murder was committed, potentially about the victim in the case, or their sensitivities, or even about things about Mr. Loyd and his background that make this particular murder more severe under the eyes of the law. Does that make sense?
yes.
That's why they're called aggravators. And they have to be present, at least one of them has to be proven beyond a reasonable doubt to the jury for the death penalty to be an option. Then, after we present that evidence, the defense would have the option of presenting evidence of what are called mitigating circumstances. And those are things about Mr. Loyd's life, background, or character that are reasons they believe that a sentence of death is not appropriate and that life without parole is more appropriate. Make sense?
Yes.
So you have the chance to hear both sides of the equation. If an aggravator is found beyond a reasonable doubt, then you all would be asked to weigh the aggravators against the mitigators. In other words, to decide how important those pieces of evidence are. And only you can make that decision. You're not going to be told how much weight to give anything. If the aggravators outweighed the mitigating circumstances, if that was your individual conclusion, then you'd be authorized to vote for a sentence of death, or that a sentence of death be imposed. Does that make sense?
Yes.
Conversely, if the mitigators outweigh the aggravators, or you just don't believe, for whatever reason, that death is the appropriate sentence, then you would be authorized, or you could always vote for life. Make sense?
Yes.
You can always vote for life. All right. That is the process. So I want to hone in on one part of it, because I'd like you to think about a scenario where you listen to the aggravating factors and you find that there are multiple aggravating factors proven, right? And you find it to be offensive, even, the crime that was committed. You would still be obligated to listen and give meaningful consideration to the mitigating circumstances. You know what I mean?
Yes.
So that doesn't mean you have to agree with them. It doesn't mean you have to find them to be important to you, but you would have to listen to them and give them consideration before you made your decision. Could you promise to give meaningful consideration to anything you heard, even if you disagreed with it?
Yes.
Even if it seems trivial to you, you would still give it meaningful consideration.
Yes.
All right? And then you could decide if it was important. Does that make
Yes.
sense?
Yes.
Okay. Anything about that process that you think you would have a difficult time going through? With the understanding, let me back up, with the understanding being that it's a very important decision. But other than that, go ahead, I'm sorry.
Yes. If everything is explained, down to legal to not legal terms, yes,
Okay.
perfectly.
All right. I believe you have not two, you have at least one child under 18 at home with you.
Yes, his 5 months.
5 months?
Yes.
Okay. Will you be is somebody there to take care of him or her for you if you're asked to be with us for 3 weeks?
Yes.
Okay, you can swing that.
Yes, I can.
Awesome, awesome. Because insanity is a possible defense in this case, I need to ask you if you or anyone close to you have ever suffered through or experienced mental illness.
No.
No. Do you believe that mental illness is a real thing?
Yes.
Right. So would you be open to listening to evidence that Mr. Loyd is not guilty by reason of insanity?
Yes.
Okay. My last question for you is there anything about your life or background experiences that you think we should know about, given that we're trying to select the most fair and impartial jury for this case for Mr. Loyd? And like, as an example, some people say, my cousin was murdered 10 years ago, and that left an impact on me. I don't know that there is, but I wanted to ask in case I forgot to ask you. Anything like that?
No, luckily I'm being blessed with a
Right, okay.
family.
Thank you very much, ma'am. Thank
You're
you, Your Honor.
welcome.
Thank you, Mr. Rowley. Ms. Mills, you're up.
Good afternoon.
Good afternoon.
Follow up a little bit where you left off. You have a 5-month-old baby?
I do.
Okay. Probably heard the judge explain the sequestration process. You would stay at a hotel for 2 to 3 weeks. The court would make some allowances for you to be able to see your family, but limited,
Yes.
and that would work?
That will work, yeah.
Okay. Would you be concerned at all about childcare or anything of that nature?
No, luckily I have my mom around and he will be in good hands.
I get it. The judge asked you if death would be an automatic penalty for someone who was found guilty of the intentional premeditated killing of an innocent victim. Do you remember that?
I did.
And you said yes.
Correct, yes.
And then it changed. Tell me what changed.
So, pretty much my background, I was born here in New Jersey, Elizabeth, and I was raised in South America, in Ecuador. So over there, like, all this, it's very natural, very common, all this kidnapping and killing and blah, blah, blah. So, of course, hearing all this news and the background, like, okay, if no one has the right to go and pay someone to go kill someone, right?
Right.
So that's pretty much what I grew up with that mindset, like, no one has that right. But of course, if things change, could be reasons of yes or reasons of no. So you need to have a proof, you need to have evidence, you need to know and hear both stories to see actually what happened.
Okay. Well, and so the first part of this trial, or any trial where the state is seeking the death penalty, is where if you're selected as a juror, the jury makes a determination about whether the state has proven the defendant guilty beyond a reasonable doubt of the crime of first-degree murder. With me?
Yes.
The second is when the jurors decide what the appropriate penalty is only if the defendant is guilty of the crime of first-degree murder, right?
Right.
And so when you talk about proof and evidence and those things, if we're in this second part of the trial where you're deciding if you're selected as a juror, life or death, the defendant is guilty beyond a reasonable doubt of intentionally, in a premeditated fashion, killing an innocent victim. Right? No doubt, that person. Then for you, is death the automatic penalty once you've decided that person is guilty of the intentional premeditated killing of an innocent victim?
It depends on the case, I will say.
Okay. When you say that, what do you mean?
Like, what was the intention? What was like the background of the person, the communication between the case and if the two individuals or the family, I don't know, and just hearing what happened. So I can change my mind or my
Okay.
opinion.
And so you're talking about like the relationship between the defendant and the victim?
Yeah.
Okay. And so I also want to make it clear too, if somebody is guilty of first-degree murder, any defense that would have been available to that person would have been rejected by the jury who found that person guilty, right?
Yes.
So like self-defense. Wouldn't have applied. So it's guilty murder, innocent victim.
Yep.
And let me say this, there are no right or wrong answers. The judge has said that as well, right? If you're selected as a juror, you take a different oath, but the oath you have taken as a prospective juror is only to tell the truth.
Yep.
And I can assure you, we all want to follow the law and follow the rules. I do. But for some of us, just from our own backgrounds, it's more difficult. And so that's where I don't know you, and so I'm just asking you, based on your upbringing, to look inside yourself and say, I hear the judge and I hear the state and I hear you, but for me, whether or not death is an automatic penalty for somebody who's guilty of the intentional premeditated killing of an innocent victim without excuse, justification, or defense.
I'm going to object, asked and answered.
I think we've had,
Sustain. Move on.
can we approach, please?
Nope, move on.
What are your feelings about the death generally?
Well, it's the max penalty that you can get. And it's something that really, something for a life-change event that happened, right? So yeah, like, can you rephrase it to what it means to me?
Yes, I mean, if I'm hearing you when you talk about your upbringing in South America, that because you were exposed to a lot of violent crime, right, it's had an effect on your feelings on punishment.
Yep.
Okay, and so death penalty, good thing, bad thing?
Good thing.
Okay, and so would it be fair to say that because you have this background that was exposed to violence, that you lean towards the death penalty?
Yes, and just let me rephrase. I wasn't involved in any violence.
I'm sorry.
Yeah, it's just hearing the news and being raised, and it's very common over there. But yes.
Okay, and so for somebody who's convicted of first-degree murder, would you say your starting place or the presumptive penalty for you is the death penalty?
I will have to hear more about the case, but things could change. But I will say yes.
Okay, and then either myself or my colleague are gonna have to do something to
Yes.
compel you to give a life penalty?
Correct.
Okay. Would it be fair to say that the thing we'd have to do would be fairly significant?
Not significant, but just explain a little bit more, like the cause and the effects.
Okay. What do you believe the death penalty should be used for?
Objection, relevance.
Rephrase.
That's what I'm trying to interpret what you're saying about your background. And it seems to me that you have a feeling on the death penalty and its purpose because of things you were exposed to growing up in South America. And so I'm trying to understand that better. If you could share with me.
Yeah, like for example, like kidnapping of kids and then violation for innocent big kids. Like, to me, right off the bat, that should be like a no, not acceptable. And major prison and whatever major penalty that person could get. Another one, I don't know, a killing of someone, an innocent person. Why they did that? Again, major penalty, or if it's a major penalty, death sentence, might as well.
Might as well what, I'm sorry?
Receive the death penalty.
Okay. You brought up a couple things I want to mention. So the judge read the indictment to you in Mr. Loyd's case. Do you remember that?
Yes, I did.
And there are several charges that he's on trial for,
Yes.
one of which is first-degree murder. There's also another count of attempted murder of a law enforcement officer, carjacking, right? So let me ask you this question. If somebody is guilty of not just premeditated intentional first-degree murder, but also carjacking, other attempted murders, does death become the automatic penalty then?
No.
Objection.
Overruled. I'm going to allow her to answer this question.
You can answer that
Based
one.
on the answer
Yes.
she's been giving.
I say no.
What makes you say that? That's what I'm having some confusion based on the answers you've given thus far.
Well, because the action of the person reacting is like, okay, oh shoot, I wasn't on purpose doing this. I don't know, the gun itself, I was nervous, stressed, or whatever it should, and then, oh crap, let me just run because I wasn't on purposely doing it.
Okay.
So my reaction is like, oh, let me just, run.
And that's where the disconnect is. For somebody to be guilty of first-degree murder, it wasn't an accident. It wasn't a mistake. There is no defense. It was with intention and with premeditation, right? So all those things you just mentioned would not apply to someone found guilty of intentional, premeditated first-degree murder. And so that's what, when the judge initially asked you that question, you said death was the automatic penalty.
Okay, I'm going to stick with death. With
Okay.
death, yes.
May I have a moment, Your Honor?
You may.
I feel like I have really beaten this dead horse. I have nothing further, but I do have a motion for the court.
State, you need to approach?
Yes, we object.
All right, ma'am. Thank you very much. You hung in there like a trooper. I appreciate it.
Thank you.
I think I'm going to excuse you from this case. You should go home and spend time enjoying your family. All
Thank
right.
you.
Thank you so much for your service. You're excused. And the last juror from the 1030 group is juror number, in seat number 10, please. This is juror number 759. Good afternoon. How are you?
I'm okay.
Is it on? Yeah, it's on.
I'm
It depends
okay.
on where you hold it, whether.
Oh, okay.
Can you hear me clearly through this mask? Okay. We just have a few questions for you, ma'am. You did say that, oh, I'm sorry. You need to tell us the truth. Don't worry about what your answer is. All we're here to find out is what you actually think and feel. There really aren't any right or wrong answers to these questions, okay?
Okay.
So you did hear about this case, is that correct?
Yes, I saw it in the news.
You saw it on the news? Mm-hmm. How much did you see?
Just I guess the first 2 weeks.
Okay, you're really soft-spoken. What?
I guess the first 2 weeks.
Try it now.
The first 2 weeks.
Okay. So when it first happened,
Yes.
how much did you watch?
Not much.
Not
It's
much?
just, I used to stay with my mom at that time, and she was watching the news, so I
Was your-
don't,
was
I
your
don't
mo-
really look at the news. I don't care for the news.
You what?
I don't care for the news, so I don't look at the news.
Okay. It's depressing. So at that time, your mom was watching it all the time?
Yes.
Was she talking to you about it?
No.
No? All right. So you watched some of it. Did you talk to your mom? So you and your mom didn't talk about it?
No.
Did you talk to anybody else about it?
If I talk to anyone else?
Yes, ma'am.
No.
All right. So other than the news, anything on the internet, Facebook, anything like that?
I mean, I scroll past on Facebook, but I don't go through or read and stuff like that because,
You just kind of see the blurb and move on?
yeah, and then just keep scrolling.
So based on what you saw, did you form an opinion as to whether or not Mr. Loyd is guilty?
No.
You have to presume him to be innocent until the state can prove he's guilty beyond a reasonable doubt. Can you do that?
Yes.
All right. All right, let me go over the death penalty with you. Do you have a religious or moral objections to the death penalty?
No.
Are you someone who believes that if somebody's convicted of first-degree premeditated murder, intentional murder of another person, that they should automatically be sentenced to death?
No.
Okay. Would you, in this case, it involves the death of a law enforcement officer. Because it was a law enforcement officer, would you automatically vote for death if Mr. Loyd was convicted?
No, ma'am.
What?
No, ma'am.
You would not? Okay. So you heard me describe the process of the penalty phase.
Right.
Aggravators by the state, mitigators by the defense.
Right.
You weigh them. You're required to weigh them. You have to listen to them with an open mind.
Right.
You don't have to accept them, but you have to be open-minded about it. You may
That's
go back
correct.
in the jury room and go, I just don't think this is important, or I don't believe this, but you at least have to be in the courtroom listening with an open mind.
That's correct.
And you weigh them, look at everything that's gone on, and then you make a personal decision, life or death. So if at the end of all of that, you believed life without parole was the appropriate sentence, could you vote for that?
Yes, ma'am.
And if you thought death was the appropriate sentence, could you vote for that?
Yes, ma'am.
All right. The insanity defense that's been raised by Mr. Loyd, it's in the guilt phase, meaning when you're trying to decide whether or not he's guilty. This is the one time in the guilt phase, it is the defense's burden to prove that. They have to prove he was insane at the time of the offense. Let's say you get to the end of the guilt phase. You've heard all the state's evidence, you've heard all the defense evidence, and you believe he was insane. Could you reach a verdict of not guilty by reason of insanity?
Yes, ma'am.
And lastly, I told you that he's been convicted of murdering Miss Dixon and her unborn child, and that he was sentenced to life without parole. You can't use that to decide whether he's guilty or not in this case. You understand that?
Yes, ma'am.
Do you have any worries about putting that out of your mind in the guilt phase of this case?
No, ma'am.
All right, thank you so much. I'm done asking you questions, but the lawyers are going to have some for you. Mr.
Okay.
Williams?
Thank you, Your Honor. Good afternoon.
Afternoon.
Took a second to figure out where we are, right? We're coming from all directions. I heard you say that you do not have a religious or moral objection to the death penalty,
Correct.
but I also heard you say that if you believed it was proven and appropriate, that you could vote for a sentence of death.
Correct.
All right. So there's a lot of area in between those two things. So I'll ask the question this way. Do you believe the death penalty is fair?
If it's warranted.
I'm sorry?
If it's warranted.
And when you say if it's warranted, what is it in your mind, a circumstance where you think it's warranted?
Well, I can't choose a side unless I hear both sides of the story.
Right.
So if I hear both sides and it's deemed necessary for him to be sentenced to death, then I'm sorry.
Try again.
Better?
Yes, go ahead.
So I have to hear both sides because I don't know exactly what happened or anything like that. So I can't choose whether or not he should or should not unless I know exactly what happened.
And I'm not talking about Mr. Loyd, because we're not going to tell you about the facts of his case because we want you to remain fair and impartial.
Right.
But when you say that you believe it's fair if warranted, that leads me to believe that you have considered a set of circumstances where it would be warranted.
Well, if it's part of the, I'm sorry. Let's see, I'm trying.
It's okay, take your time.
There's a lot of people in here.
There are a lot of people. I know it's easy for me to say to try to relax, but truly, there is no wrong answer. We just want to know how you feel about it. However you feel is fine as long as it's the truthful answer.
I'm actually nonchalant.
You actually do seem pretty relaxed. That's why I was surprised you said that.
Because I'm used to, like, kids, like, you gotta choose a side.
Right.
So I don't choose sides until I hear his side, her side, and the truth. So I have to actually listen to see what's going on, because we all know he could probably be innocent, he could be guilty, but I don't know. I'm sorry.
I believe you said he could probably be innocent.
He could be probably innocent, he could be guilty, but I don't know. I don't know what happened. I don't know the case. I wasn't watching the case, so I don't know exactly what's happening. So I'm
Right.
in the air.
And this portion of our proceeding is worried less about the guilt, but more about what your thoughts are as to a penalty or a punishment if we get there. Because this is the only circumstance, first-degree murder,
Right.
where the state is seeking death, where the jury has anything to do with the punishment. Normally, the judge imposes the punishment. Does that make sense?
Yes.
And the jury is not involved at all.
Okay.
So what I'm trying to figure out is, well, when you say warranted, I take that to mean that there are certain cases where you believe that death would be appropriate.
Well, I don't know how this case went.
Not this case.
Oh, well, let's see. Yeah, so actually, yeah.
Okay. And when you say yeah, what are you referring
yes,
to?
I'm sorry.
No. I wasn't criticizing the use of yeah. But when you say yes, there are cases where you think it's appropriate. What are those cases? Let me try to help you with an example, right? Sometimes, and it has nothing to do with this case.
Okay.
Sometimes people say, and this is serious and graphic, and I apologize, but, the rape and murder of a small child, right? There are people who say, yeah, if you do that, I don't care what background you have, you deserve the death penalty.
Right.
Is there a case like that for you?
No.
Right? But are there cases of a similar nature where you think death would be appropriate?
Yes.
Yes. Okay. But I gather from our conversation that you do not believe that death is appropriate in every first-degree murder.
Right.
In other words, you can think of somebody intentionally killing another person where it wouldn't be fair to sentence them to death. Or am I wrong about that?
So we're not talking about this case because I don't know about
We're not
this one.
talking, nope, we're not. We're talking
okay.
hypothetically or more generally speaking.
Okay. If they intentionally kill someone, then they just be sentenced to death? Is that what you're saying?
No, I'm saying if they intentionally kill someone, could you imagine a circumstance where life would be appropriate? A life without parole as opposed to death?
Yes.
Right. Because I think you told me a moment ago that there are circumstances, not this case,
Right.
where someone could intentionally commit murder and you would think death would be appropriate.
Yes.
Okay. Do you have any preference, or do you lean either way towards a sentence of death or a sentence of life in a case where a person has been proven beyond a reasonable doubt to have committed premeditated first-degree murder?
No.
You're straight up and down, straight up the middle.
Yes.
Okay. Open to either one.
Yes, sir.
I'm almost done talking about this. I appreciate your patience.
That's fine.
it is one thing to think hypothetically about participating in this process. It's another thing to like be selected and have to make this very important decision. So if you believed that we had proven what the state had proven what we need to prove under the law, could you, if appropriate, raise your hand and vote to impose a sentence of death upon another human being?
And I'm going to object. That's a misstatement of the law as to the juror's responsibility in this case.
Oh, you need to add in the mitigators. She's weighed. You need to rephrase the question.
Sure, Judge. If after you've listened to all of the evidence and you've weighed the aggravating factors that the judge referenced, and you've weighed the background, life, and character of Mr. Loyd, and you believe that after doing that, death is the appropriate sentence, could you personally raise your hand and vote to impose a sentence of death on another human being?
Same objection. Overruled. Go ahead.
You can answer the question.
Oh, okay. Yes.
Yes, okay. On a scale of 1 to 10, 1 being that you don't want to be here at all, 10 being that this is the most exciting thing that's ever happened to you, where would you rate your desire to be a participant in this process?
Overruled.
Go ahead, ma'am. You can answer.
I'm straight down the middle, 5.
5. Okay, and is that based, are you interested in the process?
It's a learning experience.
Okay, but I'm assuming you have other things going on in your life.
Yes, I do.
Yes, ma'am. Okay. Because the issue of sanity has been raised, I need to ask you if you or anyone close to you has ever suffered or dealt with mental illness in any way.
No.
No. There are people who believe that mental illness is fake or made up and is just an excuse for their behavior. Do you think that's true, or do you disagree with that statement?
I don't think it's true.
All right. So I take that to mean that you believe that mental illness is real.
Yes.
So if Mr. Loyd were to present a defense of not guilty by reason of insanity, could you fairly consider that if it was proven to you?
That he was insane?
Yes.
Yes, sir.
Okay. Last question. Anything about this process, you don't believe me, do you? Anything about this process that you think, anything about your background or life experience that you think we should know about you, given that we're trying to select the most fair and impartial jury in this case?
No.
All right. Thank you, ma'am. Thank you, Your Honor.
Thank you. Ms. Miller, you may inquire. Yes, ma'am?
Good afternoon.
Good afternoon.
I just have a couple follow-up questions about your feelings on the penalties for first-degree murder, the life penalty, life without the possibility of parole, or the death penalty.
Okay.
We already talked about, is death the automatic penalty for somebody who's found guilty of intentional premeditated first-degree murder? And your answer was no.
Correct.
Okay. Let me add a different factor to that. What if the victim in the case was a law enforcement? So is death the automatic penalty for somebody once he's found guilty of intentional premeditated killing of a police officer?
I can't hear you.
You can't hear me?
The mic keeps cutting out.
Sorry. It's the first time anyone's ever said that to me. Better?
Yes.
Okay. Same question, different factor?
It cut out.
Yeah, it cut out again.
What I'm doing wrong, I apologize.
Do you have the actual mic portion in your pocket?
No?
No, I'm talking about the other
Oh,
portion.
yes.
Yeah, pull that out for a second and see if you can clip it, or just hold it and see if that's better.
We're just going to hold it. Can you hear me now?
Yes.
Okay. Intentional premeditated killing, the victim is a law enforcement officer. So does death become the automatic penalty once you have found someone guilty of the intentional premeditated killing of a police officer?
No.
Okay. Why not?
Like I said before, there's both sides, one side and the truth. So I don't know whatever, regardless of which case it is, I have to hear both sides first. I just can't choose a decision because it's out there.
When you say both sides, is it both sides at why this happened, like in determining if the person is guilty or not?
What I mean both sides is, it could be his side, her side, and then there's a truth between both sides. So I stand in the middle of everything. I don't just choose because of hearsay or he said or she said.
Right.
I actually have to do some, well, of course we can't research, but I have to actually listen and choose a side. I just can't say here today that, oh, okay, he's guilty, he's about to die.
Right. No, and you shouldn't, right? That's the whole point, is we're trying to find folks that can hear the evidence and decide if the state has proven Mr. Loyd guilty beyond a reasonable doubt,
Right.
or if the defense has proven him not guilty by reason of insanity, okay? The questions we're talking about now, right, I know this is a lot. The first part of this trial, if you're selected as a juror, you'd be asked to decide guilt or innocence. Has the state proven him guilty beyond a reasonable doubt, or has the defense proven him not guilty by reason of insanity? Okay?
Okay.
So if we're talking about possible penalties, life penalty or death penalty, we've already made the determination that he's guilty.
Okay.
You with me?
With you.
And so that's why I just wanted to be clear when you said you have to hear both sides of, and I said there's usually three sides to any story.
Right.
His, both
Right.
sides of the truth and this in the middle. I get that. But so if we're talking about penalty, you have already made a determination at that point that the person is guilty of the intentional premeditated killing of an innocent victim.
Okay.
With me?
With you.
So what are your feelings about the death penalty then? Appropriate penalty for that person who's already been found guilty of the intentional premeditated killing of an innocent victim?
I don't have any feelings, honestly.
What do you think about the death penalty? You're doing great. I promise. There's no right or wrong answers, and I know we're putting you on the spot, and it's a lot. But we have to ask these questions. I think you can appreciate why.
Right. How do I feel about the death penalty?
Just honestly, what comes to mind?
Actually, nothing comes to mind.
Do you think it's a good thing? It's a bad thing?
No, I mean, death is not a good thing because obviously someone's gonna miss you, but I don't want to. But if that's the last resort to it, then that's what it's got to be.
Okay. What does that mean when you say that?
If once we get all the evidence or whatever, we see everything and hear what's going on, if that's what it turns out to be, then that's what it's got to be.
Okay. Let me tell you this. Death is never required. Not in any case. Not in this case.
Right.
Not in the hypothetical case Mr. Williams was talking about. Not in the worst case you can imagine.
Right.
Never required. Right? So there's no set of circumstances where you're going to have to apply the law and then you have to vote for the death penalty.
Okay.
And so that's what, when you say, like, if it is what it is, or that's how it turns out, figure out what you mean by that.
after hearing whatever, the sides, and if, not this case, right? We could talk about any other case.
Right, because we don't know anything about Mr. Lloyd's case.
Okay,
So as Mr.
good.
Williams said, we're talking in hypotheticals,
Okay.
right, just your feelings on the death penalty.
I'm actually straight down the middle of it. Death is never good, like I said before, but if, well, I really don't, I honestly don't have a clear answer for that.
Okay. Well, and we kind of got off on a tangent. Let's go back to if the guilty person, the guilty murderer of the innocent victim killed a law enforcement officer, is death the automatic penalty?
No.
Objection, asked and answered.
Sustained.
If the guilty murderer who killed the innocent victim, right, so we're deciding what the appropriate penalty is for this murder. That person also has a prior conviction for murder.
Okay.
Is death the automatic penalty?
No.
Okay. Is life in prison a sufficient penalty for the person who committed this murder that's already been convicted of another murder?
Objection.
Sustained.
Court allowed that one before.
Yeah. I shouldn't have. Let me see the attorneys at the bench.
Go back. Is life in prison a significant penalty? Significant penalty.
Significant, yeah.
Is life in prison a significant penalty for somebody, when you're deciding what the appropriate penalty is on this murder, who's been previously convicted of murder?
Yes.
Okay. In determining whether life or death is the appropriate penalty, would you be able to give meaningful consideration to whether that defendant had suffered the effects of racism throughout the course of his life?
Yes.
Okay.
Yes. Yes.
You kind of hesitated. What were you thinking?
If the mic is on,
Okay.
I can hear myself.
I can hear you.
Okay, great.
Okay. Mental illness. Could you consider whether the defendant who committed this murder suffers from mental illness in determining whether the appropriate penalty is life or death?
Yes.
Okay. Let me tell you a couple things, and we already talked about this a little bit. Death is never required, not in any case, right? And we've talked about mitigation a lot, and it's just a legal term that means why anyone would choose life or not choose the death penalty, okay?
Okay.
Mitigation can be anything, you okay?
Yes.
All right, mitigation can be anything to anyone. And it doesn't have to be unanimous. Each individual juror could find something mitigating to himself or herself, and every other juror could disagree with it.
Correct.
And aggravation is limited by law to one of 16 factors in Florida. But mitigation can be absolutely anything. It can even be something as seemingly small as observing a smile between the defendant and his mother.
Okay.
Okay?
Yes.
Okay? All right? In order for a just verdict to be returned, all 12 jurors selected for this case have to have their individual moral assessments heard in this courtroom.
Correct.
It would be a miscarriage of justice if someone on that jury's individual moral assessment wasn't heard in this courtroom.
Correct.
That's your duty, your right, and your responsibility if you're selected to be a juror.
Right.
Can you do that?
Yes, ma'am.
It's obviously a huge responsibility, and somebody's life is on the line.
Yes, ma'am.
Sometimes these things can get a little contentious in the jury deliberation room, right? And so we encourage people to deliberate, which means to carefully consider, but it doesn't mean to out-debate or bully or badger each other into just agreeing, right? And so that's your right as a juror to be treated with respect.
Right.
And you're going to treat other jurors with respect.
Correct.
And if you have reached an individual moral assessment that the verdict should be life and it's not being respected by your fellow jurors, you can be like, we're done here. Write it down, foreperson. If you're not the foreperson, get the bailiff, get the judge. We're going home.
Right.
Because if one person thinks the verdict should be life, then it will be life.
Right.
There's no such thing as a hung jury in the penalty phase of this trial because it's 12 individual moral assessments.
Okay.
You okay with that?
Yes.
Can I have just a moment, Your Honor?
Yes, ma'am.
I have nothing further.
Thank you. Either side have a motion?
No, Your Honor.
All right, thank you. All right, ma'am, we're going to bring you back for one last round of questioning. It's on another day.
Okay.
So you're no longer a green dot, you're now a purple dot. We're going to give you a purple dot. And that's because, remember I told you the colors are when you call into the jury room, you're listening for them to call a color group. There's too many of you for us to call you by number, we just call you by color.
Okay.
Okay? So now when you call, you're listening for purple dots report on such and such a date. We're not going to need you before next week at the earliest.
Okay.
It is the final day. We're going to pick the jury from the group, from the purple group. So when you come to the courthouse, you need to have packed a suitcase because if you're picked for the jury, you'll be sequestered right then and there. Just
Okay.
leave it in your car.
Okay.
Don't bring it to the inside. Just leave it in your car, and if you need it,
Sorry.
deputies will go out and help you get it. all
Okay.
right? Starting Friday, call the number that's on the slip in there after 5. So call Friday, Monday, Tuesday, until you hear that you're supposed to come back for the final day of jury selection.
Okay.
There's also a package in there about sequestration. It tells you, kind of suggests some things to bring and what we suggest is, what are the rules of sequestration and all that, so you have some ideas of what's going to happen.
Okay.
Do you have any questions?
No, ma'am.
Thank you so much for your time today, ma'am. We will see you next time.
All right.
Thank you.
Bye.
All right, do we have the other group in there? They're all in the jury room? You guys need a break? You need a break, Rebecca? Do you need a break? You can have 10. I'm going to start back up at 3:30. I put the 1:30 and the 3 o'clock together. Thank you.